My guest at this time is Rob Henneke. He is general counsel at the Texas Public Policy Foundation, where he is also director of the Center for the American Future. He is also on the front lines of the fight to repeal Obamacare now that there is no penalty or tax for refusing to purchase health insurance as mandated by the Affordable Care Act. Rob was among the lawyers who successfully convinced a federal judge in Texas to strike down the entire law several months ago. On Tuesday, he argued the case again before the Fifth U.S. Circuit Court of Appeals in New Orleans. And Rob, thanks so much for being with us.
Well, it's my pleasure to be with you. We had a very good day in court yesterday in New Orleans, and I'm excited to see how that three-judge panel rules on the appeal after winning at the trial court.
Well, we'll get into the arguments in just a moment, but let's bring everyone up to speed as we begin here. We've covered this before, but you and the attorneys general of quite a few states are essentially arguing that ending the tax for violating the individual mandate means that the argument that Chief Justice John Roberts used to uphold the law back when the case was before the Supreme Court in 2012 is no longer valid. Explain why.
Sure. So I represent the individuals in the case. Texas Attorney General is lead for the multi-state coalition. In 2012, the Supreme Court ruled that the individual mandate, which was the command in law that forced people to buy the Obamacare insurance, was unconstitutional. It was unconstitutional to force people to engage in commerce. But the Supreme Court said that because there was this penalty that people were required to pay if they didn't comply with the mandate, that you could see that as being a tax because it generated revenue for the federal government, and construing both together allowed the court to avoid striking down the entire Affordable Care Act. 2017, when Congress passed the tax cuts bill, they eliminated the penalty. And so as a result, the only thing that remains is the individual mandate command, which the Supreme Court has already said, standing alone, is unconstitutional.
What kind of questions did you get from the three-judge panel on Tuesday?
So the biggest focus that the court had, I really don't think that there is a straight-faced argument that the individual mandate can be seen as constitutional. But the struggle the court seemed to have was on the issue of severability. So the proponents of the Affordable Care Act, the liberal coalition of states led by California, and the Democrat House of Representatives, who were the side that was defending the Affordable Care Act, were arguing to the court, look, if you agree that the individual mandate is unconstitutional, just strike down that part and leave the remainder of the Affordable Care Act, leave the rest of it, just cut that part off. And so this was where the most vigorous the debate was. But as one of the justices on the panel yesterday said, Judge Engelhardt, he said, look, it's not our job to be a taxidermist for Congress. It's not our job to come in with an eraser and rewrite the law to decide which part should stay and which part should go. And I think he was entirely correct. When Congress wrote the Affordable Care Act, when it built this regulatory machine, it did so explicitly stating in the statute that the individual mandate was essential to the Affordable Care Act. So now for the people that are trying to save Obamacare that say, that didn't matter, that's not, where the focus should be. But I think that is probably the biggest debate that the court's having right now is strike down the entirety of the Affordable Care Act or just strike down part. And if so, which part stays, which part goes.
As you alluded to, Rob, the lawyers for the states against this push to repeal Obamacare have a different perspective. They're arguing that zeroing out the tax does not impact the rest of the law, as you just mentioned, or else Congress would have done so. It reminds me that Chief Justice Roberts, while also talking about the tax back in 2012, also mentioned quite vigorously that it's not the job of the courts to take care of bad legislation. That's what the ballot box is for. So do you think that argument will hold sway either at the Fifth or when it eventually gets to John Roberts?
Well, that came up yesterday, actually in a sharp rebuke of the position that was taken by the lawyer for the House of Representatives that seemed to argue that the court had an obligation to save the Affordable Care Act. Really, the panel from the Fifth Circuit yesterday said back to the lawyer for the House of Representatives, your clients need to do their job. Stop looking to the courts to bail you out. Stop looking to the courts to be activists to rewrite laws. The power is entirely in the hands of Congress to pass laws that will be constitutional and that can address the problems that you're complaining about are going to occur if the Affordable Care Act is struck down. It was really compelling line of questioning and a strong pushback by the judges against this, policy argument that was being made by the lawyer for the House.
This next question might be more of a policy question than a legal question, but let's say that whether it's this court or the Supreme Court or some other court essentially doesn't just say yes or no to the law as a whole, but they do try to dig in there and maybe remove parts that are unconstitutional without repealing the whole thing. So let's just, for example, say that they take out the individual mandate, which, as you explained, and as the Democrats said a decade ago, is absolutely essential for this law to function. So if it's not there, the system is in grave danger. Would that be an acceptable outcome to you because the law is essentially torpedoed regardless?
No, I don't think it would. I think that the trial court got it correct in finding that his job was to strike down the entirety of the Affordable Care Act because of how it was inextricably intertwined with the individual mandate. And so I think that it would be outside the role of the courts if the judges came in and then just decided for themselves which pieces to keep and which pieces to strike down. Rather, that should be the role of Congress, and it should be the role of state legislatures to adopt policy. It's, to use the analogy, Greg, it's the role of the courts to call balls and strikes. It's not the role of the courts to throw the pitches. And so I do think it's an up or down choice. I think the trial court got it correctly. And I think the panel yesterday saw it in the same way, and hopefully will affirm the trial court's decision.
It's interesting that you use the balls and strikes analogy because that's exactly what Chief Justice Roberts said in his opening statement of his confirmation hearings 14 years ago. So we'll see if, in fact, the case gets to them, which it probably will one way or the other, how he sees his role when that case gets there. As we exit here, Rob, a 3-judge panel, as you mentioned, 2 of them appointed and nominated by Republicans. And so you got a lot of folks in the media saying, well, they had a majority of Republicans on the 3-judge panel, so this is clearly going to go their way. So they see it more of as a partisan issue rather than judges actually deciding the case on the merits. What do you make of the coverage we're seeing here?
I think it's unfortunate that how politicized the judiciary has become, that when you have cases that move forward that really are decided based on the law, based on controlling precedent, which this case is here. I mean, the Supreme Court wrote the law about the Affordable Care Act in its first case, and that's what's being followed here, that we still have to accuse the outcome of being partisan because we disagree with it. That's been a result of the activism that has occurred in the Ninth Circuit and a lot of the judges who have stepped into the role of policymaking. But I think this court was looking at the law not in a partisan way, but in a legal way, and I believe that their opinion will be issued in a very well-reasoned way that tracks the law and is able to be evaluated on its face regardless of whether you see yourself as a liberal or a conservative.
And 2 very quick questions before we let you go. First of all, how soon do you think we'll get a verdict here?
I think it will take a couple of months. The trial court opinion took just over 3 months for the judge to write it, and it was one judge making his own opinion. Here you've got 3 judges that have to work together on the final product. So I think a reasonable time frame is sometime between Labor Day and Halloween when we'll know how this panel will rule. And I think it's most certainly likely that the case will then be appealed to the U.S. Supreme Court, regardless of the outcome.
So either go straight to the Supreme Court rather than the full Fifth?
I do. It was the Supreme Court that kind of rewrote the Affordable Care Act in NFIB Sebelius and then also in the second case, King versus Burwell. It's been Chief Justice Roberts. It's been that 5th vote. It's been that swing vote that has rewritten the Affordable Care Act and found ways to save it from being struck down. I think it's entirely appropriate then that this go back to the Supreme Court, back to Chief Justice Roberts to now use his own opinions as the basis for deciding whether the Affordable Care Act will remain the law of the land or not. And if so, it'll be another creative way that the court finds to avoid its own language, which has already said that the individual mandate is unconstitutional.
Rob, we'll be watching and we'll be checking in again. Thanks very much for your time today. We appreciate it.
Excellent. Thank you, Greg.
Rob Henneke is General Counsel at the Texas Public Policy Foundation. He's also director of the foundation's Center for the American Future. And as we've been discussing, he's been on the front lines of this latest effort to repeal Obamacare now that there's no penalty or tax for violating the individual mandate. I'm Greg Corombos reporting for Radio America.